Hello and welcome to a special interview for The Wire supported by Glendavid Books. Should judges who are not theologians and probably not experts in the religion in front of them take upon themselves the task of determining what practices and beliefs are essential and integral to a religion and which are not? That's the key issue that's thrown up by the Karnataka High Court's Hijab judgment, and that's the very issue I shall raise today with one of India's foremost lawyers, former president of the Supreme Court Bar Association, Dushyant Dave. Mr. Dave, let's start with what is called the Essentiality test, which, as you know, was established by the Supreme Court in 1954 with the Shirur Mutt judgment. The problem is, as I said in that introduction, should judges who are not theologians and probably not experts on the religion under question take upon themselves the task of determining which belief and practice is integral to a religion and which belief and practice is not?
Well, I think the answer to that question is that if you call upon the judges to go into a particular question, then judges are bound to go into that question and answer it. I would put it differently. Judges were called upon in Karnataka to go into the question whether the regulations imposed by state of Karnataka impose a reasonable restriction or not. And once that was raised before the judges had an obligation to go into it. Question is, what is the test that judges are supposed to apply? And that test depends on two things: the conscience of the community and the tenets of the religion. And these two tests alone can really entitle the judge to examine the evidence before them and decide whether that particular practice is a religious practice or not, it is part of religion or not. And that's the way judges should really look at it. Question is, have judges looked at it that way? I mean, I am not an Islamic scholar, but as far as I can see the judgment, I think the judges have really misapplied the law to a great extent.
I'll go into what you're saying in detail at the moment, but first let me ask you a preliminary question. As you said, if you call upon judges to go into this issue, then they will have to go into it. Why can't they actually say, sorry, this is beyond our jurisprudence? We are not experts in any faith. We are not experts in theology. Therefore, you are bringing this to the wrong authority. Why can't they say that? That would be the honest thing to say.
No, I don't agree to that, because the petitioners questioned the restrictions imposed by the state of Karnataka on the ground that it affects, it interferes with their, right, fundamental right to religion and religious practices, as also to the, freedom of speech and expression, which would also include, religious, expressions. Therefore, once, you have to test the particular action of the government, then judges have to go into it. Okay. And I think there is nothing wrong about judges going into it.
Then you made a second point. Let's go into that. You said that when judges go into it, they should do it both in terms of what you call the conscience of the community, as well as the tenets of the faith. Let's take tenets of the faith first. I'll come to conscience of the community in a moment's time. Now, when judges determine whether something is integral or essential to the tenets of the faith, they do so by relying on experts, because they are themselves not knowledgeable, not informed enough to do it on their own. And the Karnataka High Court relied upon Abdullah Yusuf Ali and Sarah Slindinja. I may be mispronouncing her name. But the problem is, experts have their own individual personal viewpoints, and secondly, experts often differ with each other. That creates a further problem, because when you end up with many experts saying different things which are not necessarily the same, how do judges determine between them? They themselves, the judges, don't have the capacity of knowing who's right, who's wrong.
You are absolutely right. It's an extremely, I would say, difficult question for judges to answer, but the answer lies in this. In one of the judgments, the Constitution bench of the Supreme Court said that so far as the Hindus are concerned, from the time they are born till they die, every action that they perform in a day is religious in character as per the Smritis. Now, if that is the kind of a wide definition that judges have adopted when it comes to Hinduism, there is no reason for any judge because a judge is supposed to apply a secular principle to a religious issue, and the judges therefore could not have said that a practice which has been followed in Islam for a long time, whether it is out of the religious scriptures or not, the moment it becomes a practice, because the right to religion is not only the inner aspect of the religion that you perform. The right to religion also entitles you to exhibit the religious practices. Absolutely. And that exhibition includes right to food or right to dress.
In fact, you made a fundamentally important point, and I'll just underline that for the audience. That particular judgment that you cited, that according to the Smithies, every practice performed every day is part of the religion, means that there is nothing that is not essential to the faith. Everything is essential to the faith. And if you apply that principle to Islam, then everything is also essential to Islam. And therefore, if you take that as a precedent, there's nothing for judges to actually go into. Whatever people do as part of their faith is essential to their faith, full stop.
See, let me put it this way. I mean, constitutional framers did not define religion because it is incapable of definition. But they knew what religion in India meant to everybody. And, take, for example, you go to a temple, take Nathadwara temple near Udaipur. It's a Srinathji temple, Vaishnavites go there. Now that temple, is closed in a day a dozen times. Now nobody has prescribed the timings of opening and closing of that temple, but that's the practice that the Vaishnavites have followed for centuries on. And once they follow, or what kind of a food is to be presented to Lord Srinathji as prasad. Now that's not written anywhere, but that's the practice which has been followed for centuries. Absolutely. So it's like that.
And that practice, therefore, is essential to the faith of the people who believe in that temple. In fact, let's pursue this one step further. You've already agreed with me that judges can only determine what's essential and integral and what is not essential and integral on the basis of experts. Experts differ, and then the judges have a problem deciding which expert do they go with. But there's a second order of problem I want to put to you. Many religions actually comprise different sects. And sects have great differences in terms of what they consider critical and essential and what they consider peripheral. Now, again, how are judges to determine between the beliefs of sects? Because sects can clash with each other. And yet, a judge, when he has to pronounce on the essential character of a faith or a belief, has to determine between different sects who often quarrel with each other over what they think is essential. So once again, it's a very difficult problem.
It is, for example, Article 25, which protects your conscience. It also allows you to practice, to protect it. It also protects the practices of religion. Now, therefore, what are these practices? These practices are what individuals and communities honestly and bona fide believe to be practices. That's the end of the matter. You don't have to go into a great, academic debate or a judicial, debate for that purpose. I think any judge with his eyes wide open would have accepted that for centuries, Muslims have been wearing hijabs. Take, for example, I'll give you a simple example. Take Naga sadhus. Can anybody object today and say that Naga sadhus should not be allowed to come in public life? I mean, it's for centuries, they have performed their worship in a particular form without wearing any clothes. Take Digambar Jains. Their sadhus do not wear anything. Now, we have to, you might say today that it is against morality, the modern, thinking of morality, and therefore they should be prohibited. The answer is no. These are all religious practices which have been accepted, respected, and worshipped for centuries.
Absolutely. And we're coming very close to verging into the second issue that I want to bring up, which is what you call the conscience of community. But I'll come to that one question later. Let me raise one more point. And in a sense, this also underlays the Karnataka High Court judgment. They determined the essential integral quality of hijab on the basis also of how many people wear it and how widely is it worn. And if it's only worn by a minority and not by the majority of Muslims, then somehow it's not integral, because otherwise the majority of Muslims would have been in a position of sin as far as Islam is concerned. And I want to put an illustration to you to show that perhaps that is the wrong way of thinking. The kirpan is absolutely essential to the Sikh faith. There's no doubt about it. It's one of the essential 5 Ks of the faith. Yet the vast majority of Sikhs do not carry a kirpan. But just because the vast majority of Sikhs do not carry a kirpan doesn't mean the kirpan is not essential to the Sikh faith. But that very logic was applied to the hijab. The vast majority of Muslim women may not wear hijabs, therefore the hijab is not essential. Surely, for those who want to wear it, it is essential, because to them, it is critical. That's what matters. Not what the majority does, but what this group wants to do.
Well, I completely agree with you. In fact, the Supreme Court has said in a judgment long back that, religious practices are something which, a section of the community may follow, a section of the community may not follow. That does not, make it, that it ceases to be a religious practice of a particular religion. So I think that test that the High Court has adopted, to my mind, is a completely wrong test. Let me read out this few lines of this Constitution Bench judgment, which has held the field for last 70 years. And this is what the judges said very beautifully. They said, there are well-known religions in India. A religion undoubtedly has its basis in a system of beliefs or doctrines which are regarded by those who profess that religion as conducive to their spiritual well-being. But it would not be correct to say that religion is nothing else but a doctrine or a belief. A religion may not only lay down a code of ethical rules for its followers to accept, it might prescribe rituals, observances, ceremonies, and modes of worship which are regarded as an integral part of the religion, and these forms and observances might extend even to matters of food and dress. Now look at it. Take Sabrimala. Every worshipper who goes there wears something black. That's a practice. People want to go in wearing a particular dress. You can't object to it. All those who go to Kaaba in Saudi Arabia wear white clothes. I mean, these are not the issues which judges should really decide in a pedantic manner. They have to decide it in a practical manner.
Absolutely. And your illustration, both of that quotation from a Supreme Court judgment and then when you talked about the Kaaba, is perfect. But for the sake of the audience, please tell me which particular Supreme Court judgment of which year did you cite?
This is the judgment of the Constitution Bench of the Supreme Court. Way back, it was in the Commissioner of Hindu Religious Endowments versus Lakshmi Tirtha Swaminarayan of Shirur Mutt, 1954 Supreme Court report.
This is the judgment that laid down what is in fact the test of essentiality. But the interesting thing is that they interpreted religion so widely, and this is often forgotten. This judgment about the essentiality test interprets religion so widely that it includes not just food and dress, but various different forms of worship. And in terms of various different forms of worship, the differences can be huge. In terms of food and dress, the differences can be huge. And hijab is precisely to do with dress. So actually, what you're doing is to point out that even if you go by the essentiality test, the way in which religion was defined by the Supreme Court in that 54 judgment actually means that hijab is essential to the faith if those women wearing it believe to be the case. Isn't that so?
Absolutely. In fact, there is a very interesting passage of Justice Davar, way back, I think it was in 1909 in a Bombay case, where Justice Davar very beautifully put it. This was some Parsi community issue. He says, if this is the belief of the community and it is proved undoubtedly to be the belief of the Zoroastrian community, a secular judge is bound to accept that belief. It is not for him to sit in judgment on that belief. He has no right to interfere with the conscience of a donor who makes a gift in favor of what he believes to be advancement of his religion and the welfare of his community or mankind.
But
Now, this passage was approved by Justice Chinnappa Reddy in that famous case where those young children had refused to sing national anthem.
Absolutely.
So it has been expressly
the
approved
Jehovah's
by the
Witness
Supreme
case, the Jehovah's Witness case. But there's something very important that you said. I don't want to lose it by going into details and citing other judgments, because I want to reaffirm it for the audience. It's critical. You've just pointed out that even when you apply the 1954 Shirur Mutt judgment's essentiality test, the definition of religion in that judgment of 1954 is so all-encompassing, so very broad, so very Catholic, if I can use that phrase, that the hijab, if it is worn conscientiously by women who believe that it is part of their faith, then does become essential. That judgment's interpretation of religion makes it clear. So when Karnataka uses the same judgment to strike down the hijab as not essential, it's doing so without fully reading the definition of religion contained in that judgment. You pointed out something fundamental and critical, that if you go by that judgment, you have to accept that judgment's definition of religion. That definition is so broad, it undeniably includes the hijab. And this brings us to the second thing you want to talk about. Because at the end of the day, what is inherent in that 1954 judgment is, in fact, if someone conscientiously believes that something is part of their religion, then it is so. That paragraph you quoted makes it clear that if some girls believe that wearing the hijab is essential to their faith, it is. You can't deny it. And the paragraph you read proves it. So Karnataka, in applying that judgment, has actually not understood that judgment's definition of religion. That's a very important point you're making.
Not only misunderstood the judgment, or rather, failed to follow that judgment, which is binding on the Karnataka High Court, but has failed to understand the width of Article 25. There are no limitations. When Article 25 uses the word practice, it means that any practice which is exercised by a religious community must be accepted. So exercise, the test of exercise was given way back in, I think, 1943 by an Australian Chief Justice Latham, which has been also approved by the Indian Supreme Court, and said that, look, if a community is exercising this kind of an act, then that act becomes a religious act and a religious practice.
Okay, this is very, very important. I'm just underlining it before I move on, because I think something that you said will be very new to audiences. The Karnataka High Court, in applying the essentiality test contained in the Shirur Mutt 1954 judgment, did so without understanding the definition of religion that is contained in that judgment. And that definition of religion is so broad that it includes food and dress that is believed to be essential to the faith. And therefore, if girls believe that the hijab is essential to their faith, the Shirur Mutt judgment itself means it is essential. That is something the Karnataka High Court didn't understand. Let me now move to a second issue, because this has also been brought up in discussion. I'd love to get your opinion and your standpoint on this. Some people say, and I think this is a position you were taking in conversations you've had with me on the phone earlier, that this case should not have been heard under Article 25 and the essential to religion test. It should have been heard under Article 19 and seen as a freedom of expression or freedom of conscience issue. Do you still believe that? Or now, does your earlier argument mean that it should have been heard under 25? It's just that the Karnataka High Court didn't understand 25 properly, nor Shirur Mutt. Which of the two?
No. I didn't mean to say that. Article 14, Article 15, Article 25, Article 19(1)(a), and Article 21. Each one of these are fundamental rights which really will entitle those professing to be following a particular religious practice to say that state has no power to interfere with it except on the ground of health or morality or public order. Now, here, nothing of that sort comes into play. See, these rights are fundamental not because they are expressly acknowledged as fundamental rights under the Constitution of India. These are basic human values. These basic human values have been accepted for centuries on. And therefore, when constitutional framers were sitting, to draft the constitution, they were confronted with this, that what do we do? How do we ensure that the basic human values are respected by the state and nobody interferes with that? So they codified into fundamental rights. So each one of them really comes into play, and they must be interpreted as widely as possible when it comes to religion and religious practices.
So then let me put the question like this. Should this case, the hijab case, have been heard under Article 19, freedom of expression, freedom of conscience? And if the answer is yes, would the outcome, even from the Karnataka High Court, have been different?
Look, our judges can't be living in a narrow compass. The judge must know the width of the constitution. The judge, therefore, when a question like this is raised before three learned judges, and I have no doubt three are very learned and respected judges, they really had to see every one of these articles, the ambit and width of each of these articles. So you have to first ensure that everybody is treated equally. 1. 2, you have to ensure that nobody is discriminated on the ground of religion by the state, and nobody is restrained an entry in an institution funded by the state on the ground of religion or religious practices. Everybody has a right to profess religion, which includes his conscience and practices. Equally, freedom of speech and expression and right to life also would include right to wear what you want to wear, so long as you are not violating the dress code substantially. You are wearing a uniform, but you are putting a head scarf. Now, I'll give you a simple example. Bar Council of India has prescribed for us lawyers uniform. We have to wear black coats. We have to wear white shirt. We have to wear a band and a gown. Now, if I were to wear a topi, can anybody object? Can judges say, Mr. Dave, you can't wear a headgear and come to my court? You go to South India, you go to Karnataka, you go to Tamil Nadu. People, even today you will find senior lawyers wearing a headgear, and they look very distinguished.
Absolutely. And the fundamental point you're making is that the Karnataka High Court itself should have been aware that Article 19 applies. They should have borne that in mind, and that should have tempered, if not altered, the conclusion they came to. That's a very good fundamental point. It's not something that lawyers have to raise as a submission to the court. Even if lawyers fail to do so, judges should have been aware, because this is a fundamental part of our constitution which they can't forget or overlook. But coming right to the end of this interview, I want to quote to you a sentence from the leader of today's Hindu newspaper. And I want to ask if you agree with it, and secondly, whether this is something the Karnataka High Court forgot. Here's that sentence. Freedom of religion is important because freedoms are important and not because religions are important. That's a very important sentence. I'm repeating it for the audience. Freedom of religion is important because freedoms are important, not because religions are important. And I put it to you, that is a principle that lies at the heart of our constitution. And secondly, this is a principle the Karnataka High Court either overlooked or completely forgot about.
Well, let me tell you one thing. It's very interesting. During the Constituent Assembly debates, large number of members had told Dr. Ambedkar that on the one hand, you are giving rights to citizens. On the other hand, you are carving out exceptions in sub-articles 2 to 6 of Article 19, where state has a power to legislate, to curtail those rights. They said these will become meaningless. Dr. Ambedkar was very conscious of that, and he said that I would assume that state will never abuse its powers in a way that these rights are whittled down in any manner whatsoever. So I personally feel that yes, freedom is something which is so sacrosanct, and the expression freedom or freedom of any kind, including freedom as to religion, freedom as to conscience, freedom as to speech and expression, freedom as to life, dignity of life, all must be so widely interpreted by the judges and so zealously guarded by the judges that nobody can really bring restrictions which are going to, raise this kind of an issue. So, you must understand, and this is what, I think this country we are today missing out, especially the party in power. Both Ambedkar and Sardar Patel repeatedly told, Sardar Patel was chairing the minorities committee while drafting the constitution, and he said that majority Hindus must put themselves in the shoes of the minority community to understand how they will feel. And it is for the majority, therefore, to ensure that the minority is made to feel welcome in this country, so that ultimately we can integrate the minority with the majority. Absolutely. This is what echoed by Ambedkar as well. But see this statement of Ambedkar on 2nd December, the Karnataka law, why this law is really unfortunate and sad. Ambedkar said, he said, no government can exercise its power in such a manner as to provoke the Muslim community to rise in rebellion. This is what he said on 2nd of December 1948. And he said that every government must be conscious that you have the power, but do not exercise power so as to provoke a minority community, which Ambedkar said on another occasion is an explosive force. We don't want this. This is a completely avoidable debate.
I thank you, Mr. Dave, for this interview.
Politics and religion are supposed to be separate.
I thank you,
no
Mr.
politician can reflect religion. So can we object if Honorable Chief Minister of Uttar Pradesh wears Bhagwa and comes to his office? No, that's his personal choice. We must respect it.
Absolutely. And if he can wear a Bhagwa and come to office in a secular country and no one objects, young Muslim girls can wear a hijab to school and no one ought to object. And that's a beautifully made point with a certain political dig that I'm sure the audience will take. I thank you in particular for this interview and for pointing out, which only I think you could have done, that even the Shirur Mutt eligibility test of 1954, if applied, contains in that judgment a definition of religion that is so broad that if girls conscientiously wear the hijab as an essential part of their faith, that definition of religion accepts, permits, and recognizes it. And that is something the Karnataka High Court, when they applied that, did not remember, did not understand. But we need to stop there. We can't carry on and on.
No, just one sentence. Mind you, Shirur Mutt's judgment has been followed by the Supreme Court in catenary of decisions. So it's the law. And it's the law of a constitution bench.
And it was misunderstood.
No court has ever disagreed with it.
And the important thing is that it was misunderstood and wrongly applied by the Karnataka High Court. And that wisdom that you've given us is what I thank you for. Thank you very much indeed. Take care.
Thanks.
Stay safe.